My name is Vinod Nichani. I'm tired. I don't wear suits anymore. I wear Costco cargo shorts and a sweatshirt in the office. So if I unbutton my tie, I'm sorry. I can't breathe. Now, any attorneys in here? Any with a law degree? Good, because that's not the purpose of this class. I'm not trying to make lawyers out of you. Okay. Otherwise, who's going to pay me the $500 an hour? The point of this class is to make money and make money the right way and make money without putting your license at risk, and what to do when you get those crazy clients, because we all have some of those who don't tell you everything at the kitchen table. Okay. There are issues involving real estate transactions that can arise around a pending bankruptcy, a foreclosure, a trust, a will, someone died. Population's growing, the population's passing. It's not your job to know what a probate or a trust is. It's your job to know the triggers. The triggers are what comes up in your conversation with your client that would require you to seek assistance on their behalf. Okay. I'm not telling you to tell your client, oh, you know what, you need a trust. Why don't you come to my bathroom and I'll help you draft a trust? No, don't do that. Your job is to say, hey, you know what? I think you probably need to talk to a lawyer. Why don't you do that? And then your job would be to have a good relationship with someone who you can refer to, or someone who's open with you to help your client complete that transaction. Because guess what? In the end of the day, if you want to buy that Tesla, you need that commission. I don't advise buying them though. But so I have an outline. I probably won't follow it. Okay, I'm sorry. I do draw pictures because I think it's fun. That's a Smurf house. I tried that. But in the end of the day, what I want to get you to see is that there's a method to follow with these transactions that'll help you to the end goal. Okay. We'll touch on the basics of the laws. I'm not going to give you code sections or in-depth law, because when I was a realtor, when I was sitting there, 10 minutes later, I'm falling asleep. I'm already trying to make deals. I don't care about what's on the screen anymore. I door knocked. I did that. I cold called. I called one lady and she said, don't ever call me again to sell my house. So I said, I'm sorry, ma'am. Would you like to buy one then? Oh, that was hell. That was hell. I got yelled at, man. It was crazy. That's when we had those Palm Pilots. You remember those things? Yeah. So I've been through it. So anyways, because of that, I think it's important that you know these triggers. I know you. Hey, what's up, man? So the key here is to take away what these points are. So we'll go through my outline. Okay. Again, I won't follow it. If you have questions, I would suggest, if it's a question about my friend has this problem, come on, guys. You know, I would suggest I'm going to sit right there in that corner. You can come and pick my brain about every possible legal issue you want after the class. I would suggest you do that. If you have questions during class, the only problem I will say is that I'm not going to answer everything, because your situation might be more in depth than you think it is. So it won't be a 1 or 2 minute answer, right? I mean, you might say, oh, I want to file bankruptcy. My friend wants to file bankruptcy. There's 10 chapters. It might be a bad idea, you know, or my client has a will. Okay, well, what does that mean? So ask your questions if you need me to repeat something or analyze something that I'm talking about. But if it's in depth, take me in the corner, pull your notepad out, ask me questions, and you're not going to get charged. That's freaking awesome. I'll sit right there. So do that, but that's up to you. Okay. Can you guys see the screen? Okay. So Nichani Law Firm, I'm in San Jose. We're predominantly a litigation firm. So my view today is going to be when everything goes bad. Okay. Involving trusts, wills, probate, bankruptcy, you know, we'll touch on different areas. We do a lot of different areas. I mean, we've done neighbor disputes, real estate disclosures, Ponzi schemes, a lot of Ponzi schemes these days for some reason. I don't know why. So we have a lot of that. So there's different areas which I'll touch on, and a lot of crossovers. So in the end of the class, I'll go over a crossover situation where there's a dead body in the backyard. There was FBI. Mom died without a trust. Daughter had no money. I thought she was going to kill me. And they came to my office and we saved the house. Pretty awesome. Okay. So we'll talk about that. But the key components of that case is what you really want to understand. So, okay. Let me go through the type of attorneys so you know. There are transactional attorneys and litigators. Transactional attorneys are the ones who draft the contracts. Such as if you want to go and complete a complicated real estate transaction, you go to a transaction attorney and he goes over all the contracts, what you need, what documents you need, such as estate planning attorneys. Those are transactional attorneys. The transaction are documents. You go to them and say, I need an estate plan. I went to LegalZoom and they screwed it up. What do I pay you? Okay, pay me this. They'll give you a will. They'll give you a trust. They'll explain those documents to you. That's transactional. Litigators are where, for example, what's up?
For Zoom.
Oh, what do I need to do?
Yeah, so they're able to hear you on Zoom.
Oh, I need to be on the mic?
Yeah.
Oh, Jesus. That's gonna be loud, homeboy. Hello. Oh, thank you. That's much better. Okay. I threw my hands in the air.
All right, you should be good to go now.
Are we in cocaine Zoom land? Okay.
I'll have you place
Thank
this in your
you.
pocket.
All right. All right. So, it's okay, Neil. So what I'm saying is that, for example, let's say in a case I have right now, we have mom who passed away and she has 3 daughters, and daughter number 3 is the trustee. Okay. Daughter number three is responsible for keeping accounting records of the trust, because mom passed and she dedicated daughter number 3 to be the accountant, well, not accountant, the trustee, to manage the trust. So daughter number 1 says, hey, sister, I need to see the accounting. Daughter says, no, I'm too busy. I don't want to deal with you. There's a conflict between 2 daughters. Okay. What happens then? Daughter number 1 calls me and says, hey, my sister, daughter number 3, is not releasing the accounting. I don't know what's happening with the funds. I'm a beneficiary. I'm entitled to this. So that's when they hire someone to go in and litigate the matter. File the complaint, file the petition probate court, get in there and resolve this dispute. So those are litigators. Okay. It's important to know this in your situation, because you're going to be dealing with lawyers when one of these matters come up. When a bankruptcy or a trust or probate issue comes up, you're going to need to know these lawyers to properly connect with, maybe to refer your clients to, or maybe for yourself, who knows. But the legal field is just like any business. It's like me going to a residential realtor and saying, hey, can you get me a lease on a commercial building? They're going to say yes because they want the money, but they're going to screw up the whole deal. That just happens, right? Or a commercial realtor who knows nothing about residential, and they're going to say, oh yeah, I'm licensed, so I can do this deal. No, you can't. You're going to try. You're going to screw it up, and you're going to see me anyways. So that's the situation. So you really want to know those differences. Now, another thing is, in the customer service arena of lawyers, especially estate planning, and I'll say this over and over for you guys, you want to go to a lawyer that specializes in estate planning. The reason being is that the laws change so much that you don't want somebody who's like partially in estate planning but doing a bunch of other things. And I'll say that myself. I don't touch estate planning. It bores me, first of all. I hate talking transactional stuff. But you don't want somebody who's got 1 foot in here and 1 foot somewhere else, because they're handling your life, they're handling your family, they're handling your future. So go to someone who does that, and I would say only. Now you're going to get some exceptions, of course, and it's a general term, but in most situations, there are a lot of lawyers out there who just do estate planning. It's a volume business, then they do that. So you got a client comes in and says, I need a trust done, or I'm in a probate, or I need an administration. You can go to these attorneys, they're going to know it. So it's, you want to understand that kind of carve out for lawyers. Okay, so this is my Smurf house. Kids, what are you going to do? So you can understand that in a real estate transaction, it could involve any one of these areas: bankruptcy, trust, and probate. And the thing is, in any one of these legal areas, it's going to involve something called an estate. You have a trust estate, a probate estate, a bankruptcy estate. This estate is going to include all the assets of that individual bankrupt person or the deceased person. I talk really fast, so if I'm going crazy and smoke coming out of my mouth, just tell me, okay? Or if you're bored, just throw something at me. But so the question is, how are you going to take that real estate out of this estate, and how are you going to sell it, and how do you get paid in the end? Right? That's the key here. I mean, commission is the goal. You like that? See, in green. Okay. So key takeaways for today: basics of these areas, triggers, your team, and you're not an attorney, so don't try to be one. That's like me trying to be well, I'll step back on that. I do try to be a real estate agent once in a while. I shouldn't do that though. Okay, so how to complete a real estate transaction where the pending bankruptcy, probate, or trust administration. Let's start with we'll start with bankruptcy. I'm seeing bankruptcies go up. I filed 4 bankruptcies in the past 2 weeks. I got 2 foreclosures coming up, which I need to stop. So I'm seeing that right now. Is anybody else seeing the market changing in that sense? Yep. Okay. Now I don't know if that has to do with job loss. I don't know if that has to do with loan modifications adjusting. I don't know if people just aren't able to pay interest rates. It could be various reasons, but I'm seeing it. Now, bankruptcy is an interesting field because there's a lot of advantages, business tactic wise, and there's also a lot of help for people who are financially in distress, and they give you a lot of options. The intake process of bankruptcy is generally a client's going to call the attorney and say, look, I'm in a lot of debt right now. I can't meet my expenses. I can't pay my credit card. I can't pay my medical bills. Or at least in your situation, I've defaulted on my mortgage payments and there's a foreclosure sale coming up. What do I do? Okay, because these guys, at least in this market, the foreclosure might be on Monday, but they have like $400,000 in equity in the house. And if it gets foreclosed on, they're not going to get that $400,000. They're going to get a lot less because everybody's going to eat it up. So what can we do for those clients? All you can do is say, I understand that there's a foreclosure coming up and you'd like me to sell the house. Let me suggest a bankruptcy attorney to talk to, or someone to talk to help you deal with that situation that's so urgent. And maybe what could happen is that bankruptcy could stop the sale. I don't know. That's my understanding. Talk to an attorney. That's your job. Okay. My job would be to, have them come in and I get to know their financial situation, their assets and liabilities, and try to strategize the correct bankruptcy chapter for them to get them the result. They can either work on keeping the home, they can buy time to sell the home, or they could just buy time to live in the home for a few more months and let it go. There's so many strategies that could be used for bankruptcy. Okay. Everybody following me so far? Make sense? Am I talking clear? No language or anything? Just kidding. It's not court. You get so familiar. I mean, even if you say the F word to me, I'll answer to it because I'm so used to it right now. Now, I would say bankruptcies are going to pick up. Okay. And what's going to happen is people are going to come to you in the last minute and say, oh, I was working with the bank, but now I can't get a modification. So my house is going to sell Friday. Okay, what do I do? Right? You want that deal. You want to sell that house. You can. You can spend a little bit of money, clean it up, put it on the market and get that money. Get the commission, make the client happy. But what do you do in a week? How do you stop that sale? Bankruptcy is filed on the computer. So, for example, my first daughter was born and I took my laptop to the hospital and my client had a foreclosure the next day. I filed bankruptcy from the hospital and stopped the sale of his house the next morning. Now, is that risky? Yes. Did he gain 3 million in equity by now? Yes. So was it worth it? Yes. So it's so there's so many methods to do it and urgent filings you could do. Would I advise that for a regular client? Probably not, but you can. Because once you file the bankruptcy, everything stops. It's called a stay. It stops there. And so long as you notify the lender timely, that foreclosure stops. Is it stopped permanently? No. It's a minimum time period for you to figure stuff out. It's a relief. It's time. That's what it gives you. So when you refer your client to an attorney, a lot of realtors actually come with their client to meet me. They're like, because the client doesn't know. They don't even know how to sell the house. That's why they came to you. Now you want to put them in a bankruptcy, they're not going to understand it. So it's very helpful for me if there's a realtor coming along and the client approves it to talk to me about the situation, because in a lot of cases, real estate agents are more than just helping you sell a house. I mean, your job is to be a life friend for everything. I mean, that's the best customer service you could provide. So they come over to the attorney's office and they say, hey, the realtors say, look, the sale is on Friday. I've talked to the bank. They're not helping. There's nothing we can do, or there's no answer on the modification. So we do an intake. We talk to them and find out all their income and assets. And then we decide what chapter to go on. Okay, there's chapter 7, there's chapter 13, there's chapter 11. Chapter 7, I'm trying to follow this. Chapter 7 is a liquidation. So what that means is that they don't really have any assets that are non-exempt. For example, and I'm not going to give you exact numbers, just I want to clear the picture. Let's say, for example, you had a Tesla, like I said, and your car's worth 40 grand, but you have 10 grand in equity in there. Okay. So if you file bankruptcy, you lose the car? No, you can exempt the 10 grand. You can keep that 10 grand. There's different code exemptions that they give you. So you can file chapter 7, get rid of everything, and maybe keep that car, keep that equity. Okay. Because maybe a car equity might be 3 to 4 grand, personal property maybe 20 grand. It just depends what you want to keep. But more likely than not, you're going to file a 7 and you're going to get rid of everything. Say, I don't want anything, just get rid of my debt and I'll keep whatever minimal stuff I have. I mean, you could keep 600 up to 600,000 in equity in your house, the homestead exemption. You could do that. So there are ways to keep the house in a chapter 7. More likely than not, you're going to face chapter 13s. Chapter 13s are the only bankruptcy where the person who filed, which is the debtor, can withdraw the bankruptcy without an approval by the court. Does that make sense? So if you file a chapter 7 or a chapter 11, you have to ask the court and say, hey, can I dismiss my case? And people can object. That would suck. You don't want somebody to say no to you. But chapter 13, you could file and you can dismiss it. So in this example, I'm going to show you. Now, these are obviously not real numbers, but let's say the property is worth $2 million and you have a first of 1.2, okay? And then you have a second of 300,000. Can you guys see that?
Yeah.
All right, look at that. You can see it now, right? So you have a second of 300,000, okay? And then credit card debt of 50,000. Now, the debtor, the bankruptcy filer, has missed 10 payments, okay? 10 payments on the first and 10 payments on the second, all right? And they got a foreclosure date. Hey, that's a couple of days. Oh my God. There's no freaking way I'm going to be able to gather information from the clients, who's probably dysfunctional anyways, because they probably don't have any paperwork or anything organized. There's no way I'm going to be able to get all the information from them by December 1st. They're going to be like, oh, at Thanksgiving, I'm full. I can't find my papers. I got to go to Santana Row and hang out for Christmas. Who knows? What other issues are? Suddenly stopping their sales, the last thing on their mind, really, right? Okay, so we can do something called an emergency bankruptcy filing. An emergency bankruptcy filing is literally 3 to 4 pages of the filing, which I do on the computer, that will stop the sale. And all it takes is a social security, name and address, and some minor information that I could file the case and I can notify the lender to stop the sale. Okay. Then what happens is you have about 2 weeks or even a month to put the supplemental documents in, which are the schedules, assets and liabilities, transfers, taxes, things like that. That can be done. But if I file the day before the first and I let the lender know the foreclosure happened, it stops the sale, which is cool. But then what happens is that bankruptcy estate is formed, which we talked about in the beginning, this estate, okay? And in order to keep the property, the debtor has to start making their regular mortgage payments. So they've missed 10 payments, but now they got to make their regular mortgage payments and start over, okay? But what happens with the past due payments? That's when a plan is created, okay? So let's say, for example, 10 months times 10,000. Oh, Jesus. 100,000. Yeah, there you got a math person right there. So you got 100,000 there on the first. Okay. And then you got the second mortgage that they've missed 10 payments on. That's 20,000. Okay. That's 120 in secured payments, which is the mortgage payments that they've missed. All right. Now, they got unsecured debt of $50,000, which is credit card debt, right? What that means is that they can't really foreclose on the credit card. It's not connected to any asset. So unsecured creditors in bankruptcy don't always receive 100%. They can receive 10 cents on the dollar, 1 cent on the dollar. It depends on what your assets are. So if this homeowner ends up having any equity, which it seems like they do, they have 1.5 on debt and $500,000 in equity. But they really don't, because they have $600,000 homestead exemption. So really, based on the house, there's no equity, because that homestead exemption engulfs the equity. So there's no equity. So the credit card would get 0. Okay. So you would pay them 0. All you would pay for then is $120,000 times approximately 10% in interest, whatever that number is, divided by 36 to 60 months. Okay. So that payment gets started from the month of the bankruptcy filing. You pay that minimal payment plus your mortgage, and in 5 years or 3 years, you're current and you keep that house and you keep the equity. So there's a huge benefit for this chapter 13 for people who are hurting now, but can keep going in the future. Questions, concerns, jokes? No? Okay.
So it means file before December 1st, so they can stop the bankruptcy.
Yeah, you got to file before that. You have to.
Pay 120K before December 1st.
No. The 120K is divided into a payment plan. over 3 or 5 years. So it's just like buying a car. Let's say you buy a car for 120 grand, you pay monthly payments. Is that monthly payment plus the regular mortgage? So you stay current on your mortgage, your taxes, your insurance, and you throw that payment in, and that's how they keep the house. Okay. Now, let's say, for example, this client says to you, I kind of want to just stay for a couple of months, clean it up and sell it. What do you think? That can be done because this bankruptcy gives you the option to dismiss the case. Well, so does a chapter 11, but this one is pretty easy. So what you could do is you could stop the sale. You could put a plan telling the court, look, I just need 3 months. Let's say it's December and the market's slower in December. You want to sell in June, hot market summer. Is it still like that? I think so, right? Yeah. Who knows, man? This market's so freaking crazy. So it seems like a hot market every day. So in a normal life, you want to sell in the summertime or spring, you're going to hold a few months. So in the plan, you're going to tell the court, hey, Your Honor, I'm going to sell in a few months. I'm going to make my monthly payments to the creditor so they get off my case. And you can negotiate that also because they know you're going to sell and they're going to get all their money. So they'll work with you. So you propose a plan saying in 3 months, I'm going to sell. The judge says, okay, in 3 months, you list the property subject to bankruptcy court approval. Okay. Then once an offer comes in, if everything's good, open escrow, you get the HUD-1 ready, you do all that stuff, and you file an application with the court, a motion to move the court to approve the sale of this property. Now, I'm going to talk about this in the end, but who are the players in this transaction? Lawyer, well, title company, and the realtor. Who's the most important? Besides the customer, who's the most important? I do consider myself the most important because I'm a lawyer, but that's not correct. The most important is title, because they freaking ruin everything. They ruin who are the title people here? Anybody? I love you and I love you, but you guys ruin everything. Yeah, exactly. Luckily, I'm hourly, so I don't give a crap. But you guys ruin everything. But here's the deal. In the office of title, you have these hotshot lawyers that are looking at the transaction and they're going to say no, right? So my job as the attorney is to prepare an order. After the motion's approved, there's a final document that goes to the judge and the judge signs that order, ordering approval of the motion, okay? That order is the goal. You need that to complete the sale. Now, if I send the order into court and title looks at it after and says, oh, you missed a period. Dude, there goes my deal, right? So what's the most important thing to do? Have a title officer with you. Get the order to title. Let them approve it beforehand. You dealt with that, you know that. Dude, you got business cards today? All right, we'll talk after. So if they've approved the order and then you get it signed by the judge, you're good to go. Because these things are fast, man. I mean, you know how quickly the buyers are waiting. You don't want to lose your buyer. They're just hanging out going, oh, dum-de-dum, I need this thing to sell. No, be proactive. Get title involved, get your attorney involved, get everybody involved and close this transaction. Because once that order comes through, it's done. Now imagine if title says no, you got to go back to the judge, who already doesn't care that much about you anyways, because they probably hate the attorneys. And they're going to be like, oh, now I got to go through it again. I got to review this order. It's a, can I say this is a shit show? So be proactive. So that goes back to kind of what I just said over here. What you take away from here is your team. You want to have your team with you because they're the ones who are going to close the transaction. So anytime it's a legal matter, I would say have the attorney and have the title involved. Right? I mean, yes, sir. Yeah. Oh. Hello. Right. That's the problem. I mean, how realistic is it, right? I mean, you got to really look at where the individual is in their life. For your purposes, you want to get this transaction completed. I mean, I hate to say it, you don't really care if they can keep the house. The key is, can they sell it? Because you're putting this time in, right? You're not here to help them keep their home. You're here to sell their home. Okay. Now, as good customer service, you say talk to the attorney. The attorney might tell them, you have the option of keeping it. Sorry, then you guys have lost your client. But then if you guys are already in the same set that I want to keep it just for a little bit of time to get this thing sold, which is usually the case. If they can't afford it after 10 months, good luck keeping it. I mean, let's be realistic. I mean, hopes and dreams wise, come on. But there's still an opportunity for us for equity. You guys can stage it, you can clean it up, you can throw in new paint and carpet. You can do that and you can get it sold. And that could put money in their pocket and your pocket. So it's your good value that you're providing them to introduce them to an attorney, but it's not a guarantee the attorney is going to answer your question the way you want them to, because they got to look for the client's interest, right? But does this happen? Have people saved homes? Yes, many times. Is it hopes and dreams a lot of times? Yeah, a lot of times it is. I mean, a lot of these things start out with good intentions, but they eventually get converted to a Chapter 7 because they can't keep it, or they dismiss the case. I mean, I've done things I'm not proud of. I've filed client bankruptcy 10 times for clients and they haven't paid a mortgage in 10 years. Hey, Trump did it. Why can't my clients do it? So it's a strategy. Don't judge me. It's a strategy. It's my job. Now, can I do that for everybody? No. But bankruptcy is a tool. Okay. There have been, I mean, we've done it for clients where, like I said, I filed it the night before. We've done it for I've done it for clients who owned care home businesses, you know, and the home is actually owned by them. And that's their business at the same time. I got one right now, 6 years later, she's been making her payments. She's gonna be done pretty soon. And the home has gone up like crazy in value. There's more people to service. So she's doing great. It is an amazing tool for clients and an amazing tool for you to refer for your clients, because they will appreciate it because they get to keep their asset, or they get to work with you to get them that equity that they've been saving on forever. I mean, you know how hard it is to keep equity in a house? People have leveraged it up like hell. And now the market is so high that if they can keep a little bit, it's amazing for them. I mean, it's hard to save 50 or 100,000 bucks if you're going to get it from a home. You file a bankruptcy. Now, the problem is it's going to kill your credit, of course. I mean, if you file a bankruptcy and you dismiss it, it's on your credit. It's not a discharge. But if you stay through the full bankruptcy in a Chapter 13, you're going to have your discharge on your credit. Will you be able to get loans and stuff like that? Yes. Will you pay high interest rates? Yes. But you'll have to start over. Now, the Chapter 13 payment plan is going to be 3 to 5 years. Okay. Chapter 7 is going to take a couple of months, and then the discharge happens. Now, if there's a business or more, well, let me take a step back. In a Chapter 7, there's a trustee. Okay. So once you file bankruptcy, there's this third-party independent person who has to evaluate all your assets and liabilities. Their job is to find money. Okay. If they find money, they take a piece of it and they distribute it among creditors. That's Chapter 7. So you can imagine they're pretty aggressive. So if you guys decide to give all your assets to your sister before filing bankruptcy, they're going to find it. Do people still do it? Yes. But they're going to find it. They're going to bring it back. Okay. Now, Chapter 13 has a trustee also, but they're a little more hands-off, because in the Chapter 13, you're working with your attorney to put a plan together and pay people back fairly. Okay. Now, Chapter 11, there's not much to say about it. I mean, Chapter 11 these days is like a supercharged Chapter 13 for individuals. It's really for businesses, reorganizations. But individuals might go into Chapter 11 if their debt is too high or equity is too high. And that's a complete nightmare, because it's an administrative nightmare. And the reason being is every month you have to file these reports with the court disclosing your full assets and liabilities for all the creditors to see. I mean, people don't have that type of resources or that financial background to put that together. So it's a nightmare. So, you know, we don't go into that too much. It does happen, especially for the high income earners or high real estate level owners, but mainly you're going to see the 13s. So I would imagine, assuming, well, based on my experience, and I think we're going to see more 13s come up, more bankruptcies, and that's what I'm already getting calls for. So I would definitely try to have an understanding of that. So your job would be to meet the client. If you hear the word foreclosure, trustee sale, things like that, I miss my payments, I want to sell, immediately talk to an attorney. Because they might tell you they missed 5 payments, but actually they missed 15. Right? You know that. They're freaking so full of crap. You know, they're in 15. Or they might say, I think my foreclosure sale is coming. Or I have an interest in this house, I own it. No, you don't. Who gave it to you? It's not in writing. Like some people out there, you know, my dad said I could have this house, and his brother said he could have. Okay, do you have anything in writing? No. Okay, well, how do I fight this then? My friend will tell you that she was there. What? You know, What are you guys doing? I mean, it's just, unfortunately, there's laws and there's requirements that are there. But again, don't be lawyers, just make suggestions. Okay. Like, how many of you guys advise on 1031 exchanges? I know you guys do. Don't give me that. Are you licensed?
Referral.
There you go. Referral. Refer it out. Don't advise on it. Don't advise on taxes. Don't advise on law stuff. Don't do it. I wonder how you could say it. From Google, what I read is, oh, there you go. That might be a way out. Google said, okay, any questions on bankruptcy? Go for it. In 11? Well, title is most important all across the bankruptcies. Okay, so I think I'll go through my fun example next, running out of time. Dude, we just touched on it, but let me give you I'll give you the example. It covers the 13. Okay. So this is the house here. And this is the backyard. Okay. On Monday, the client comes to my office and says, Vinod, I was referred to you. My house is going on foreclosure on Friday. Okay. I want to stop the sale. Okay, great. That's awesome. Can I see a title or a grand deed in your name? It's not in my name. What? Then why would you be able to stop the sale? It's my mom's name. Oh, then have your mom come in. Mom died. When? Last week. Okay. So mom died last week and you want to sell mom's house and get the equity because you're the beneficiary. Yeah, it's my house. Okay. Anything in writing? Of course not. All right. Well, mom died. Does she have a trust? No, of course not. Why would anybody do anything proactively? No trust. Okay. Has there been a probate? What's that? Okay. No probate. What is probate? Probate is the ability to clean up title, right? So what's going to happen is you're using the process to transfer title from the deceased to the beneficiaries. Am I right, title guy? Okay, you like that? All right. So I'm going to get to your question in this example. So title is still in the mom's name, but she's dead. And guess what? She's being investigated because she beat up her boyfriend and buried him in the backyard. And the husband's missing. So now you tell me, how does that affect value? You got two dead bodies. Okay. I know. But in this market, it wouldn't matter anyways. So if she hung the guy and the husband in the house and beat up the boyfriend in the backyard and buried him, all right, there's your valuation, Mr. Appraisal guys, wherever you are. Rob, you know this. Where are you? You've been around long enough. You know the answer. Okay, so we got a minor FBI problem. There's always two sides of the story, Rob. So, okay, anyways, you got a few dead bodies, you got some sniffing dogs, you got cops, FBI, whatever. Okay, we deal with it every day. Did you know U.S. Marshal is M-A-R-S-H-A-L versus Marshalls, the store, the different name is confusing as heck. We saw them too, by the way. So, anyways, one point back. I started my practice as a solo, so I get a lot of crazy stuff. One time there's a terrorist in my office. I'll tell you about that next, but I stopped the sale. So what happened is, so you got this lady, she's like, it's my house. I'm like, it's not even in your name. How am I going to stop it? Okay. Now back then there were a lot of foreclosures and it was just a mess because people weren't paying attention to stuff except for title. So I go and I say, look, you got nothing. Let me get a probate attorney involved to start the probate process. So probate gets started and the only way title can go to this person is through probate, right? So the probate attorney gets involved and she makes her the personal representative with the court and she gets approval to sell the house. Now, in order to sell the house in probate, that personal representative has to have something called letters, these documents that give her the right to sell it. And then they either have full powers or partial powers. If it's full powers, they can go through the process. If it's partial powers, it's more court involved. Am I right? Yeah, you know that, right? I see that title head movement. I know all this stuff already. What's he talking about? So now she got full powers. Unfortunately, she got full powers. So she goes and lists the property with the realtor. Now, I will tell you, a lot of realtors are pretty familiar with probate and they use the CAR form. And then a lot of realtors think they're familiar with probate and they know crap. In fact, they fill the form incorrect anyways. Now, so they get the property listed and they get a buyer. Okay, now what do? Well, I take that back. They get the property listed, but there's a foreclosure on Friday. So I got no buyer Friday. I got a probate process started, and I got a foreclosure coming up. And I think this lady's gonna kill me because she's really scary looking. So I don't want to lose my life, and I want to get paid. Hopefully, I didn't get paid, by the way. I got screwed. But anyways, interesting case. So what happens next is, can I file bankruptcy for her to stop a foreclosure, that property not in her name? No. How can you do that? It's not even her property, right? That's crap. Okay. Can I file bankruptcy for her who is expecting the property to be in her name? That's still crap. But guess what? I filed it anyways. Now, do I advise this? Was it a fluke? Total fluke. I filed it. I stopped the sale. The next day, I got 4 calls with various choices of words from banks who told me I was full of it. Were they right? Absolutely. Did I agree? Absolutely not. We call it posturing in law, right? I could have no case. I'm you're going down. You're going down. I know everything. I'm full of crap. Like, you got to do that. It's all sales, guys. Come on. So in the end of the day, the judge, who I think would have thrown me out of this courtroom, gave me 2 months. Which is awesome, right? 2 months. You got 2 months for the real estate agent to fix up the house or the probate to get completed. Okay. So what happens is we find the buyer. Okay. The buyer comes in, and the probate attorney has to get approval of the sale in probate. Okay. But I have a pending bankruptcy as well that stopped the sale. So I need a court order from bankruptcy court as well. So we've gone through all this work, and we're over here. Now, imagine if, and I think the probate attorney screwed up, not me. She filed the order from probate court, and she got the order, but guess who said no to it? Title says no. He's smiling. You know you do that stuff. But since I was proactive, I got my order approved, so whatever. But I had my order approved, but probate is holding back, and the buyer's getting antsy. So she had to rush in and get another order from the probate court and from title. So to answer your question, the people who look at the order are going to be the judge and title, because title in no way wants liability. They want to make sure that order looks good. So it's always proactive to get the order to title beforehand, to know they're going to approve it before you send it to the judge. And that could be in any bankruptcy and any probate. Okay, because bankruptcy, when it's filed, there's an estate created of all assets. So if anything's sold from there, you have to have the judge and title review it, because it's going to affect the title of the property. That's your question? I did go a little crazy. Okay, good. So we got the orders done. Am I right, title people? Yeah, okay, good. So title was done. I got my orders. The house sold. We saved the house. She got $400,000, and she still didn't pay me. And then she disappeared. So I don't know where she went. But the key here is that if title had not approved my order as well, or let's say the judge was on vacation, we would have been screwed. We'd have no order. The buyer would have gone, and who knows what would have happened. That property would have been gone, and she probably would have killed me because she was scary. So the key here is the savior for me was title, because I took the time with my officer, an underwriter. She looked at everything. She said, this will be approved. I'll give it to my attorneys. They look at it. They say, okay. Judge signs off on it. In fact, I think it's easier to work with the judge than the title office on an order. They take forever, but they got it done. So it goes back to my original point where you got to know your team. You all have relationships with officers. You have relationships with attorneys. Develop that team. So when this deal comes along, you can pick up the phone and say, hey, I'm working with this attorney. Do you know him? If they say he's a jackass, don't go there. But they know the attorney. They know the officer. And you can get these things done. Orders are so important for completion of transactions. And you're not supposed to advise. You're supposed to connect. Okay? Questions? Yes, ma'am.
Make sure you guys are doing mic Zoom. I just wondered if different counties have different rules in California, or is it really state law?
In what aspect?
Well, things like going to a probate or going to a bankruptcy judge, could it be different from Santa Clara County to Placer County?
It's not really the law, it's the way they do things. Like, for example, if I file a motion in probate court in Santa Clara, holy crap, I gotta wait forever. They're so backed up. But if you go to San Mateo, maybe they're more effective. Or a bankruptcy judge. So the bankruptcy judge I dealt with at that time was totally friendly to the bankruptcy filers. Now the problem is he retired and all the judges are friendly to the banks. So it's an uphill battle for me, right? If I represent a creditor, I'm awesome. I love it. If I represent a bankrupt, man, they're so difficult to do anything. So you have different judges who do different things. So that's one thing to know of, number one. Then you have local rules. Like, okay, what's the timing, or what time are the hearings, or what does the judge expect from you? So you have your law, which is going to be the same. It's the applicability of the law that may be different with the judges or the counties. You have the Superior Court of San Jose, San Mateo, you have different ones. But bankruptcy court is districts. You have Northern District, you have San Jose, San Francisco, and Oakland are within the Northern District. When you go to Fresno or you go up north, it's a different district. So it just depends. Like, I was doing a neighbor dispute, which was a nightmare. My God, it's worse than a freaking divorce. I was doing a neighbor dispute up in Marin. And I literally think the judge hated me because I wasn't from there. I thought he just hated me. I mean, I won, but I just, like, the whole time I was like, this is horrible. Or like, it's for me, I'm a civil attorney. If I go to family court, it's different. I'm not going to know the way they do things there. So everything is different. So that's why when you interview your attorneys, you kind of understand their experience and stuff like that. It's not hard to figure it out, but it's just good to know somebody who has an experience with the area. Yes, sir.
Yeah, here we go. I'm looking at the challenges for the realtor. And I was specifically looking at, you have a client who needs to sell immediately. However, it's a declining market. From your experience, how long does it take to get the court order and things so the realtor can continue selling the home?
So most court orders, so it's called a motion. You're moving the court to get a result you want. Most court motions will require about, I'd say, a month in time to notice it. So everybody gets to see it and object to it, okay? You can do emergency motions. So for example, let's say I know the buyer is gonna walk in a week. So I have to file my motion and ask the judge, can you hear this motion in less time, in shortened time? Then the judge might say, okay. And then I have to immediately notify everybody and say the judge has approved an earlier hearing. So a lot of times when it comes to a sale, we can do that because we don't want to lose the buyer. Now, the realtor has to provide the information to his client and to the attorney. You're going to know the status of the buyer or how antsy they are to walk in a declining market. You don't want to lose that buyer. So you would advise the attorney and say, look, this guy's going to walk. We need this done right away. What's the quickest way you could do it? And then the attorney can advise you accordingly, set the hearing, things like that.
And from your experience, what have you found as far as the range of days?
Oh, I've done it in a week. It just, it's again, it goes back to experience with that judge, how picky they are. I mean, I've had a time where the judge picked up the phone and told me, this is what you do, I'll get it taken care of. Holy crap, that never happens. It's just weird. But these days, most experienced attorneys are going to have an inkling of what exactly will happen. And if you tell the judge, look, I'm going to lose this buyer, there's not many out there, they're going to understand. So for the real estate, the realtor's purpose, that makes sense. Give a reason. Okay.
Yeah, Attorney Chani, I've gotten same phone call before back in the Great Recession days. So my question is more towards process.
Mhm.
I told the guy, sorry, I can't help you out, but how soon can you file? I mean, how quickly can you stop? Like how close to the 12th hour? And how long will that skeleton bankruptcy will take place?
So it depends on the money.
And the third question is, how well did that bogus filing that you did, were they able to save it to probate?
The bogus filing was saved, but that will never happen again. And then if they bring gold or cash, I can file it faster. I'm just kidding. Just joking. So the key is I could technically file it an hour beforehand. The problem is going to be how soon that notice of filing is received by the lender. Because let's say they don't see it and they foreclose. It's a nightmare to unwind it. So to answer your question, it can be filed an hour in advance and I've stopped the sale. Would I advise that? No. Do it the night before if you have to, or do it the day before. Okay. The bogus filing was only saved because that particular judge I felt really supported people filing. But I could not do that. I mean, I could, but I'll probably get yelled at again. But it's not guaranteed what happened. So the process. What's your next question now?
Yeah, so the skeleton bankruptcy, how long, you say you get filed an hour before, and how long does the process take as far as meeting with you? Because I walked in that house, it was real with the white notices and Probably stack green letters while you talk.
Yeah, so you could file it, an emergency filing. So one thing that's required for consumers, the person who files bankruptcy is required to take an online course. Or even a live course for like an hour, hour and a half on financial counseling. I don't care what they say on the course, just get me the certificate because that gets attached to the bankruptcy. So we file the emergency bankruptcy. Then you have 14 days to work with the client and get all the supplemental documents in, which are assets, liabilities, things like that. Because what could happen is the trustee could say, hey, you shouldn't be in a 13, you should be in an 11 when they see those numbers. So things could change. But so you get that filed and then that process is started and then you have to work with the court to get a plan filed to keep going in the case. Now, a lot of times what happens is someone will file an emergency filing to stop the foreclosure. Then they let the case get dismissed. Because if you don't file the documents in 14 days, the case is automatically dismissed. Okay. Then they file again a second bankruptcy. But that second bankruptcy only gives them a 30-day protection unless the court allows them to have that protection again. If they let that go and you do a third bankruptcy, there's no protection. So there's various timelines you have to follow in the bankruptcy to buy that time. So if they're going to file the first time, they need to know, don't screw around. Or if you do screw around, these are your options. That sounds so bad, huh? If you're going to mess around with the law, you should know to do it this way. But that's kind of the deal here. So I would say 14 days protection if you don't want to file any documents, because sometimes they might not want to because they don't want to disclose, right? I mean, you might get a client who's smiling and saying, hey, I'm your best client. And then you file the bankruptcy. Oh, I'm not going to give you anything, because they already know that they know the game. So it just depends. But for your purposes, you see a bunch of white notices, you tell them, go see an attorney, Huh?
I didn't know any better than
Oh.
I just don't.
Just don't tell them you should file bankruptcy. Here's the paperwork. Yeah, don't do that. What else? Yes.
Like a lawyer essentially is what's gonna determine we're gonna file it.
Yeah, so 11 and 13 are pretty much, they're similar, but 11 is for a lot more debt in the millions and a lot more income. People come to me with 11s. Let's say they have a house worth $4 or $5 million, a couple million equity, or they have a business, individual business, or the corporation. They file an 11. If I can get them in a 13, I would, because that's cheaper. A 13 is going to cost you no more than 10 to 15,000 bucks for the basic case, and you can pay that over time. 11 for me is a 20 grand retainer, and I'm billing it hourly. Chapter 13 is based on flat fee from the court, kind of like a probate. They give you a court list of fees. 11 is a lot more work because you have to get involved with the judge a lot more, the court. You have to file monthly documents. You have to explain financial situations more. Even though you're in control as the debtor, it's called debtor in possession, they possessed all their assets, they're still under scrutiny of the judge and the creditors a lot more than in a 13. So that's the difference. But they can do either. I mean, 13, again, is a lot cheaper, a lot more streamlined because you have an independent trustee. And 11 is a nightmare. I mean, it can get crazy. There can be litigation, a lot of different stuff. We can get litigation anywhere, but usually 11s are pretty complicated. They're fun though. Okay.
Check out the fees. Like average, 13, 7, and 11, what's the fee you charge?
So if it's an individual 7, that's pretty simple. It goes between 2,500 to 5,000. If it's a complicated one or even a corporation, it can go 15 to 20, depending. 13s can go 10 to 15,000 on a flat fee, which is a down payment, and the rest of the fees will go in the payment plan. Okay. If it's a complicated 13, then sometimes the attorney can get an approval to charge hourly. 11 is generally a $15,000 to $20,000 deposit billed hourly based on the attorney rate. My fees gone up? Not much. Not much. Still the same. Okay. How are we doing on time? Where's our time person?
It's an hour. We charge an hour.
If I like the person, about 500. If I don't, 600. No, just kidding. No, we're going up to 525 an hour from January. I do 425 for my associate, 250 for my paralegal. I just started. I mean, there's a big firm was like, how much do you charge? I used to charge like 425. And they're like, what's wrong with you? I'm like, well, yeah, good point. And the mortgages themselves are so freaking expensive. And rent is so expensive. Everything's expensive these days. But hopefully provide value where the Hourly fee is approved. I don't know. She said 10 to 11 and there's so much more to talk about. Just keep going. Oh, whatever. Okay. So, all right. So we did bankruptcy and I didn't follow my outline. Look at all this stuff here to talk about. Oh, it's all boring stuff. Anyways, okay. Listen, who knows the difference between a probate and a trust? Okay. So who said me? He knows it again, the title guy. So in the process of retaining or completing a living trust, okay, a living trust is really, if I break it down to simple terms, an estate plan, okay? Now, a lot of you are going to go online or you're going to go to an attorney and you're going to get something called an estate plan. An estate plan is a bunch of forms that comes in a pretty binder. It's usually like a purple binder or maroon, depending on the attorney, what he orders. So you get an estate plan, which involves a revocable trust, okay? Revocable trust means that you, as the creator of the trust, the settlor, could revoke the trust and amend it during your lifetime. Okay. Now, when you go to the attorney, you buy this package, you're going to get your revocable trust, you're going to get a pour over will, which pretty much pours all the personal property into your trust. Then you get a power of attorney, you get advanced healthcare directive, and you get a certificate of trust. Okay. The certificate of trust is like a summary of the trust. The purpose is if somebody asks you for your trust, you're not gonna give them a copy. It's private. Why would you give me a trust? You give them the certificate, the bank or whatever, because the certificate just gives them the information they need. You don't want to share your full trust with them. Okay. I advise getting an advanced directive from the hospital because the nurses, you could probably read it better, but most attorneys give you one. Okay. That package itself comes in a binder and you put it away. Now, you can go online and get it. You can get it from your attorney. I would never advise online because everything's probably tailored to particularly what you want. And it goes back to what I said, that you want to get a specialist in estate planning because the rules change, the numbers change. They're complicated things. I mean, it has to do with a disclaimer trust, a split between the AB trust, who manages this, who manages that. I mean, there's so much litigation around trusts right now. It's crazy. Just because it goes back to bad accounting of handling the money after the deceased. So there's so many different things that come up. So you really want to get an attorney who can handle that. Now, when you have a trust, it's a private document, okay? There really isn't any court intervention unless there's a dispute or some kind of court order you need to complete some kind of sale or do something like that. Now, when you're dealing with the trust, after someone has passed, the process is called trust administration. You're administering the trust. Who administers the trust? The trustee. Okay. So in that trust, you're going to say if the settlor, the creator of the trust, is the trustee when he's alive, he or she's alive. But when he or she dies, it goes to the next person, which could be the spouse, or let's say the spouse is gone too. It goes to a trustee they've picked. Okay. So let's say, I don't know, Mickey Mouse is your trustee, for example. Okay. So Mickey Mouse is your trustee. So Mickey says, hey, you know what? I'm the trustee of this trust. And my job is to manage and complete all the requirements of this trust for the benefit of the beneficiaries, pursuant to the wishes of the person who passed. Okay. Oh, just stretching. Okay. So now what happens is, let's say one of the properties in the trust needs to be sold. Okay. So the trustee would retain a real estate agent and they would sell it as trustee of so-and-so trust. That'd be the seller. Okay. How does this apply to you guys? This applies to you because when you're doing your initial consultation with your client, you need to find out, do they have the authority to sell this property? Or are they just talking like they own it? And you might have the beneficiary who's not even a trustee wasting your time saying, I want to sell this house. Okay, can you sell the house? No. What the hell are you doing here then? I could be across the street with a real seller. You know, so for your purposes, you want to get in the habit of asking these questions. Now, if you go to a house, more likely than not, the house is completely destroyed on the inside and somebody's not done something, somebody's passed or whatever. It just seems like that, right? So it's either they're foreclosing, default, or a dead person. So you want to ask these questions and make sure the authority, ask them, say, are you a trustee? Do you have authority to sell this house? And if they say so, then you continue the conversation. Okay. And in a trust, you can pretty much do what you want because it's a private document. Probate is not private. Probate is a nightmare because it costs a lot of money, it takes forever, and the court's involved. So that in that situation, you would ask the individual, are you a personal representative of the estate? And if they haven't done anything, if they haven't become a personal representative, or they haven't taken this trust or understand the trust, that's when you refer them to an attorney before you move forward. You say, hey, I think you should meet an attorney to figure out if you have the authority to sell this property before we move forward. Otherwise, you're wasting your time. Right? So these are questions to ask in that sense. Now, the next issue you're going to face is that if that personal representative of the probate has the authority to sell the house, that's fine. But more likely than not, like I said, in most cases, there may be some pushback from beneficiaries. Okay, so you want to make sure that you understand this individual situation. And I would just say in any situation, if there's a probate or trust, get them an attorney. They're not going to know it. They're going to more likely to not mess up somewhere. They might get sued for accounting. They may get sued for self-dealing. They may sell their house to their best friend, take the money and run, and nobody knows about it until a realtor finds out later. There's so many things that happen. I mean, it sounds kind of self-serving, but I would say get them an attorney, get them a CPA before you even get involved. Okay, that makes sense. Okay, we went through that. Tell me.
I'm just curious. I want to clients and they made their trust 20, 30 years ago. Is it your recommendation that they should review the trust? I do that before I even think about selling the home. First thing I say, have you seen an attorney about your trust? That's the first thing I ask them. But my question is, what do you recommend as far as keeping it up to date or whatever? Because some of these people, as they go on in age, they starting to forget. And well, anyway.
I would definitely advise to take the trust and get it reviewed. The reason being, property has been sold and purchased. They've had children, grandchildren, things that need to change. But the main thing is also, and again, I don't do the drafting of it. I do the litigation of it. But I do know there's been changes with the AB trust, where there's a distribution between the bypass. When one spouse survives, one spouse passes. There's been changes. So I think at this time, everybody should probably get the trust amended. And that's the reason for the CPA also, right? Because there's a lot of tax ramifications when it comes to these trusts that people just don't know. So I think you're doing a great service by having them review their trust.
Now, my question would be, what's the liability to the realtor if they don't bring that up and it just kind of goes through and it does go through a sale as a trustee, only to find out there's all these occupants on?
Well, it's not your duty. You're just providing a customer service. You're saying, look, I'm not a lawyer. You have a trust, go talk to an attorney. And that's it. If you want, I can refer somebody to you. That's it. Your job is not to say, let me look at your trust and make sure you're a trustee. I wouldn't even go that far, man. Yeah, I'd say Google told me to see an attorney. Go see the attorney. Or Yahoo or whatever you guys use. Because you know what? People sue for everything these days, right? I mean, if I'm going to sue somebody, I'm going to sue them for everything I can think of, every cause of action, just because I can. So, exactly. I mean, you can sue for everything. So one thing I do find though, and I'll go, I'm all over the place. When you're in litigation, you see so much crap out there. But I will tell you one thing realtors just absolutely suck at, which you guys should walk out from this room as this is the only point. Send confirming emails. If you talk to somebody and if you sneeze, you should send them an email saying, I'm confirming you sneezed on the phone and that's my record. You got to do that because when I come to sue you, I'm going to ask for all those documents. And if you didn't tell me you sneezed and somebody else did, you're in trouble. Yeah, you better put that down. I better get a confirming email on that.
The question is, if the trustor died, and the trustee, and then she get at least in the deal, but you can't sell the house without attorney, right?
Well, does anybody really need an attorney? No. Should you get an attorney? Yes. But the trust is going to say that the trustee takes over the power to sell the property. My suggestion is that you don't say anything. As long as you know there's a trust, go see an attorney. Does that make sense? You shouldn't be reviewing the trust for them and answering their questions. You should tell them, I know there's a trust. I just want to make sure we're doing it right. Go talk to an attorney.
How much you charge?
Me? Well, 525 starts in January. I'm 425 now. Get in while you can. I'm just kidding. Yes, sir. Your friend or you? There you go, man.
The guy is, there's two trustees, the main and the co-trustee.
Mhm.
The main trustee is 96 years old,
Okay.
and, he took away the, trusteeship from the doors, and transferred it to the caregiver.
Mhm.
Caregiver, and, now the co-trustee is the caregiver. So I said, okay, we can sell it, because I said, you have to read the estate plan. And so I saw that they did the scheme, so I got it the title. I got even a copy of the estate plan in the title.
Yeah.
And then the title said, first title company, I approached for, I was approaching, I approached two. First title company said, no, you have to have the children sign to agree to the sale of the house.
The beneficiaries, right?
But they don't say why. And so I said, oh, surprise. So I mean, then let's try another title company. So from First American, we went to Fidelity. Fidelity said, no, you can just sell it because and so, what you have to do is record. It's not recorded in the county, although you're in the trust, it's not recorded in the county. Excuse me, I Googled, I said, you don't have to record it in the county. With him as a co-trustee, so they wanted it recorded, title company. So the notary went there and then talked them, and then suddenly the title company told me that no, they need children to sign.
Yeah.
And the power of attorney was not enough for them to sell it, what title company says. They're always that's right. So I think you just have to be, he's still alive, you might have to make him sign.
Mhm.
But if I was thinking, I would have the knowledge that it might be, I might be accomplished with like making him sign. Even if it's only
Absolutely,
6 years,
absolutely.
it's not a problem. So that's the case. Title company, I guess it's a scale.
You're talking, yeah, he's talking to you.
What I'm saying, so title company does not agree that we can sell the house without.
See-
Stewart.
Well, you know what? I'll be honest with you. The minute you told me the caregiver is a trustee, we had a problem from there. That's the problem right there, man. Yeah. So in that example, I would stay far away from the case without an attorney. Because you got somebody in a position, a caregiver in a position of attention and reliability and confidence. I mean, I don't know.
We can afford it probably, and
Yeah, they're messy.
Expenses would be on the trust.
Exactly. That it's
Not mine, yeah.
no. But see, you're in that situation as a realtor, I'd be like far away from it.
But I only want to, but the guy's running out of money. And,
Well, there's the problem right there.
the focus, he wants to sell the property at 2.5 million.
Yeah, yeah.
And, he wants to sell that so he can continue caring for the guy, because children do not care for.
See, that's the issue, right? Unfortunately, in any business, if you get involved too much, like when I hear caregiver and trustee, I'm getting my invoice out. I'm ready to rock and roll. Well, if he's alive, then the question is does he have capacity? Right? You have somebody without capacity sign, and you take it to sign, you're in trouble. This would have been a better, I know somebody. No, you got to approach it. And the problem is, I don't know how many lawyers would even take it because it's so hairy of a case. You know, like for me, well, title won't touch it until everything's cleared up. I mean, they need every option to avoid an objection, right? If beneficiaries sign, everybody's okay with it, they're in the clear. Somebody doesn't sign down the line, they can come back and they're gonna sue you guys. So that's the issue. Beneficiaries signing on it, everybody approves. Yeah, make sure he dies first. But that's the problem, right? You gotta, title's not gonna touch it until everybody's clear. If they do, they're putting themselves at risk. Just like an attorney. I mean, I need to know everything moving forward. Who am I gonna represent? Am I representing the criminal? Am I representing the fraudster? Am I representing an honest person? You know, it just depends. And I gotta know that so I can do the best. And our hands are tied as lawyers, right? So. Yeah, I'm not talking about you, that's fine, but I'm saying in a situation like that, more likely than not, there's some corruption involved with the trustee or the caregiver. It's such a standard pattern. Everything becomes like a standard example, you know, it's like, we've seen this before, and then you little nuances in each case. Yes, ma'am.
Have you ever had a situation with the parents challenge the trust and what was the outcome?
Oh, yeah, I've had that.
Could you repeat the question? He's been in a situation where the heir challenged the trust and what's the outcome?
So I've had that situation where the heirs challenge the trust, and then it can go even further. Maybe there was another trust, or maybe another will. The problem is going to be whether or not the challenge has sufficient evidence to support that. See, probate court and bankruptcy court are courts of equity. They're looking for fairness. So if I'm going to go to court and say, look, Your Honor, this trust is crap, the heirs say so, based on what? You have a trust document. Do you have a competing document? Then we need supporting evidence. We have to have an evidentiary hearing to support both positions. So we've had that, but my situation was a little different because I had a little more complexities to it. But I would say in your situation, without more facts, it's going to be an uphill battle. It's always, I mean, these things get so convoluted, you really have to have more facts and evidence. Yes.
I always hear it's so difficult setting up a trust, that's why people don't do it. So what's involved in setting up a trust?
That legal term is called laziness. It's
true. It's so simple and not expensive. And I tell that to every client of mine. It's like, it's not painful. And it literally takes a maybe 2 visits. And I mean, personally, I have a very complex trust. 2 visits.
Yeah.
Yeah.
I mean, it's like underwriters, loan underwriters. You know, their job is to, you know, get the documents, make sure everything's done and produce. That's all it is, right? That's all a trust is. You're gonna, I mean, most attorneys are gonna give you a questionnaire, right? You're gonna fill in the question. The hardest part is not the attorney, it's your job. Who do you trust? Are you gonna have your druggy kid take care of it? Or are you gonna have your other kid, the CEO, take care of stuff? Is the druggy kid gonna feel bad? Probably. But those are things you're gonna be crossing through your mind and talking with your family about. And you give that information to the attorney. They're gonna fill in the information, draft the documents, you're gonna sign it, they give you a binder and you go home. It's really easy. It's not as complicated. The problem is people go in there, meet their attorney, put their deposit, don't show up for 6 months and they die. Half the trust is done, right? So that's the problem. Everybody should have a trust, bottom line. That's the most important thing for the benefit of your family members, for the people who are going to receive, because otherwise their money is going to go to probate court. Things are going to take forever. Attorneys are going to get paid quite a bit of money, especially in this area. That's the benefit of it. They shouldn't, but they can. People have done it. People have done crazy stuff out there. I mean, I've had one where this lady had gifted a house to somebody, and in the deed it was trustee of her trust in joint tenancy with this individual. We fought about that for months and months because the trustee wanted to take over the house, and I'm like, wait, it's joint tenancy. You can't just argue that. So there was a back and forth, and you're welcome. And then another trust came out, and it was just a complete mess because she had so many properties. Or maybe last minute she couldn't find her original trust. She made a new one, and then the old one pops up. Just, it gets crazy. Of course, no worries.
So let's say something.
Well, that's going to be well, the trust is private. Whatever doesn't go in the trust will have to be probated. So what happens a lot of times is somebody goes and refinances their property, and the lender tells them you need to, or the lender or title maybe tells them you need to take the house out of the trust to complete the transaction, then put the house back in. They don't do that. They die. So then you have a trust and you have a house sitting outside, which needs to be probated. So then the attorney needs to go to court and do something called a Hegstad petition, basically saying, no, there was an intention that that property be part of the trust. And once we get that, then it gets distributed via the trust. That makes sense? Kind of, okay. If you get 10% of it, we're good. So, man.
Is it a possibility to reverse as soon as the axe falls right here at Market Street? Is there a possibility to still reverse that or go in there and try to talk to the courts to
Reverse what? A foreclosure?
foreclosure? Because it's happened so many times, like, you know, I see it, I watch this.
Yeah.
There's a deed coming up, there's people don't act on it, like the same guy going to Santana Road. So, you know, all in.
It's, you know, it's not a guarantee. I've seen it happen, a wrongful foreclosure. There are many, many issues that could come up, whether the bankruptcy is filed at a time and they didn't know about it, whether it was done incorrectly, whether or not they followed proper procedure of the trustee sale. There's so many issues. My experience is that a lot of people who bring up the wrongful foreclosure action are using their resources to fight, hoping they can make a deal with the bank. Whether they can legally support the wrongful foreclosure is minimal. But the pressure they could cause and the problems they can cause for the bank being in litigation forever may get them a result. That's what I've seen. It costs them, I mean, if they're willing to throw money at it, yeah, they can get that and the bank could see that and say, oh, you know, we're tired of this crap, let's make a deal. And then you got guys who are going to say, oh, the original note wasn't signed, or this is wrong, this is wrong. I mean, there was a whole time where the notes were incorrect or not serviced correctly, which you could argue, but it just costs a lot of damn money. You better hope your equity is like really high, because then there's a gamble on it, you know?
Plus it's on that side, log in all those hours.
Oh, the more they spend, the more you spend, the less likely to settle. You know, it just depends on the situation in that sense. You got it. All right, what else? We could spend another hour.
So the trust or the will or just before they're old, they transfer to the kid.
Get a trust, hire you to sell their house, sell the house, take your commission, take them for dinner, and be happy.
I mean, for the older, before they die.
Well, no, I mean, if they're not like, if they have the ability to understand that they're signing a trust, I would say a trust.
But trust, you said also when the sell, they need an attorney, right?
You don't need an attorney. You don't need an attorney. You don't need an attorney for anything. There's stuff who does probate themselves. It's just a cleaner process. It's like somebody trying to sell their house for sale by owner. That's all it is. I mean, you know how many people screw up when they sell the house for sale by owner? It's scary to even buy it from them. So it's just the same thing. You want, when it comes to these issues, such as like I said, transactional issues, documentation issues, it's better to have an attorney.
But for my knowledge is if they have living trust, they pass their way, the trustee is the kids can sell the house without attorney. It's fine too, right?
That's fine too. Yeah. Yeah. But the problem is they won't know how to do it to protect themselves. Let's say you have one brother who's a trustee and the other brothers don't like him or might not agree with his sale of the property. Then what do? You have a dispute. It's the dispute we're trying to avoid, right? So when there's a lot of money and when there's a lot of money at hand, disputes are going to come up, right? That's just kind of the philosophical, spiritual kind of thing I'm throwing into my conversation here.
If it's one case, no argument, it's fine, right?
I think if you have a family that's all with each other and comfortable, I would still say you just need the simple advice of an attorney for process purposes, because a trust is a complicated document. It doesn't make sense.
But you said just get a trust certificate. But usually if you go to the bank, you change your account to be trust, they need a whole document.
They'll say no, give them the certificate. Certificate is a summary of the trust. If this, you know, you want to avoid disclosing your trust document as much as you can. The certificate is a summary of it. They just get to confirm who the trustees are and beneficiaries will say it on that document. They don't need to see all the provisions, who gets principal, who gets rent. They don't need all that stuff. For what? They just need, yeah, they're full of crap. Tell them no.
No, they cannot.
Go to another bank then. It's like most bank, like for example, if you want to, if you form an LLC and you want to open a bank for an LLC, a bank account, some of the banks don't even know what the heck to do. You have to go to a business bank that actually understands that here's the operating agreement. You can open the account. If you go to a consumer bank, they're not going to get it. They're so freaking weird. They just don't understand. That's not title. That's banks.
Yeah.
Certificate of trust. But I wouldn't even go that far. I would just say talk to an attorney. Because you know the problem is clients are going to hear what they want to hear and say what they want to say. I don't want you guys wasting your time on a deal that may not happen. You know, keep it clear from the beginning. What if they give you the certificate of trust, but you don't know in court right now there's a pending lawsuit to kick her out? Do you really want to get involved with that? No. So, and they're not going to tell you that either because they forget.
So let me go back to the certificate of trust. So what you did there?
You're gonna have the co-trustees, you're gonna have the trustees, you're gonna have possibly benefit. It just depends what it's drafted as. Do you have a copy of it? Yeah, okay, so you should give that when they ask you for a trust, you can give them a copy of that. You know, of this, whoever, if the bank or whatever. But are you a trustee?
No.
Then you shouldn't be dealing with it. Yeah, get away from it, man. Don't even talk to them. They sound painful. Don't even talk to them. You're putting yourself in arm's way. Get out of it. Yeah, don't, you can be nice, not that nice. Yeah, get out of it. Talk to him, he'll take care of you.
They don't want, they need the beneficiaries to be informed.
He can figure, they know ways around it. They're good. Yeah, yeah.
I'm gonna ask you.
Yeah, you don't need a lawyer, you need title.
But I have my-
Yes. Yes,
Send a certificate of trust, it's just one piece of paper.
it could be 1 or 2 pages. Yeah, it's a small page.
It's writing certificate. of
Yeah,
trust.
yeah, certificate of trust. It's just a summary. Yeah, yeah, yeah. Thank you, sir.
Set up-
Talk later. You too.
If you set up living trust without the certificate, you can ask your attorney give you.
You can ask them to draft it for you. Yeah, yeah, it's not a big deal. It's just another document. They can do it for you. Questions, concerns? Anybody else? Yes,
You
ma'am.
wanna be-
What's that?
Do we have your-
I have cards, which I finally brought, which I never do. And here's my information also. There you go. Look at that. Awesome.
You to use this one.
I do litigation in bankruptcy, business, real estate, and trusts, and I do bankruptcy filings.